When people fall in love and get married and create a home together and begin building their family wealth, they don't plan on one day having to divide it all. Yet so many couples find themselves separating or getting divorced, and that's exactly what happens. My name is Stephanie Weissenstein, and I'm an attorney at Grimm Rupert. While my current practice is focused on real estate matters, in a previous life, I was a family court attorney. If you or your real estate client is going through a separation or divorce, or have received property pursuant to a family court order, it is important that you work with an experienced real estate attorney to ensure the property division happens the right way. Sometimes, it's just not realistic for either spouse to keep the house in a divorce. Maybe the house is the only asset, or maybe there isn't enough other assets to buy out the spouse if the other wants to keep the home. Maybe neither spouse can afford the home or qualify for a refinance. In that case, they may decide to sell the home, and that can be done during the divorce even if there is not an agreement about how the money will be divided. The net proceeds from the sale can be held in escrow pending a final agreement or divorce decree. Or, if there is an agreement, both people can take their share of the equity and put it towards their new life after divorce. Most of the time, however, it is after the divorce is finalized that the parties will list the house for sale, and the settlement agreement or divorce decree specifies how the funds from the sale of the house will be divided. If a couple is separating and only one person is on the deed, can the house be sold? Well, that depends on if anyone has started a divorce or separation lawsuit in the family court. If not, then the property can be sold by the person on title. If someone has filed an action in the family court, then the property is part of the marital estate, and it can be sold only by agreement of the couple or by court order, regardless whose name is on the deed. That's because under South Carolina divorce laws, marital property is defined as all real and personal property acquired by the couple during the marriage and owned by them on the date that the marriage litigation is filed. In most cases, even if the home is titled in only one name, it may still be considered marital property under South Carolina law. Now, where a lot of issues crop up is when the spouse who kept the house after the divorce tries to sell it. Most family court attorneys will include language in the divorce decree or agreement that says one person will sign a deed over to the other, but then they never actually get the deed done. So years later, we have to track down the ex-spouse to obtain a deed. It's important that parties going through the family court process also consult with a real estate attorney. If you have any questions about this topic or other real estate matters, please do not hesitate to reach out. We look forward to meeting you.